everyone. Good morning. This is Ravina, and I am today in conversation with Ms. Rebecca John, who needs no introduction whatsoever. She's the woman of the hour right now. If you're watching any news channel, she is a senior advocate who practices at the Supreme Court. Her inspirational career involves representing, individuals in several landmark cases, including the Hashmipura massacre case, Arushi Talwar matter, Harshad Mehta case. She's also represented Kanhaiya Kumar, the Delhi Chief Minister. More recently, she successfully represented Priya Ramani against MJ Akbar and is presently an amicus before the Delhi High Court in the marital rape exception matter. Interestingly, she is the first female advocate with a broadly criminal practice, was designated as a senior by the Delhi High Court. So her inspirational career could take pages and pages, but without further ado, thank you so much, ma'am, for agreeing to speak with us today.
Thank you. Thank you, Ravina, for having me here.
Likewise. So just to begin, could you tell us a little bit about your journey? What drove you to be a lawyer and especially practice criminal law primarily?
Okay, so I was just another regular student who went to Delhi University with no real future plans in mind, with one thing taking over another. I was very clear that I did not want to do the traditional routes, take the traditional routes like teaching or becoming a bureaucrat. My father was one, and he was very keen that I take the civil services exams, but I was very clear that that was not something I wanted to do. And so while in Delhi University, I had a lot of friends at law faculty who were senior to me. And I came to the conclusion that perhaps this was an option I should explore. And then I spent 3 years at the law faculty. I enjoyed those 3 years. I began to notice that I was deeply inspired by the people who had been students in the law faculty, who were then doing very well in courts. Some of them had even become judges. My journey into criminal law was equally accidental. I did not particularly decide for myself that I wanted to become a criminal lawyer. In those days, it was, as it is now, it was very difficult to find placements in good offices. And so a very close friend of mine, whose father was a leading trial lawyer in Delhi, criminal lawyer in Delhi, who knew me from before, wanted to, one day sat me down and asked me whether I had any plans of joining the profession. And I said I did. And then he said, "Who are you planning to join?" I said, "I have no options." And then he said, "This doesn't look like it's going anywhere. So I'm going to refer you to another friend of mine who's a leading criminal lawyer in Delhi." And that friend turned out to be Mr. Dinesh Mathur, senior advocate. I visited him, his offices, while I was still taking my final semester exams. And, that's the first time it struck me that this was a office which predominantly practiced criminal law. And so the nuances and the language and the cultural milieu was very different from what I had expected a law office to be. But be that as it may, I decided to go on to join Mr. Mathur once he accepted me. There was already, surprisingly, a woman in that office, somebody called Neelam Grover, who was till then the only woman who was practicing on the criminal side in the Delhi High Court. But otherwise, it was a predominantly male office. And that's how my journey began. And once I got involved, I never really looked back. It was an extremely encouraging space, I will say that. It was a space which, once they overcome the reservations that they normally do about whether I'd last the distance, whether I would just walk off after a few years, once they were clear on those issues, I think the office gave me the platform, the opportunities, and the encouragement to be who I am today.
What drove you to take on such matters and represent such sections of society throughout the course of your career?
So I have when people ask me who I am, and I always say I'm a criminal lawyer. I'm a trained criminal lawyer. And so while I practice criminal law, I have done the whole gamut of cases, from representing victims to representing accused to typical IPC offenses, to the more elevated kind of white collar crimes that you see now, from PMLA to Prevention of Corruption Act. Scams relating to banks, etc. So I have always done a mixed bag of work. And in the initial years of my practice, which was those were years where I was attached to a chamber, the training I got was really to appear on behalf of accused persons. We had a whole bunch of high profile matters that I appeared in, along with Mr. Mathur or independently, and that actually gave me the confidence to take on matters. I think the fact that I have consistently also appeared for victims or for people who otherwise don't get representation is my duty as a lawyer. And I believe that more and more lawyers should do that. I see that there are many people today, for example, who take on these matters, although they are skilled, high-profile lawyers. It is important that while we do the regular kind of work, we also don't turn away people who genuinely require the representation that we can give them. And therefore, that's been a principle that I have stood by all my life. I have been, the journey has been very kind to me. I have appeared for a wide range of people, and I see no reason why I should not use my skills and seniority to represent people who genuinely need that kind of representation. The Hashimpura case was one such case, in which it was a very moving story of how 44 people were killed in a custodial encounter. It's probably the worst case of custodial violence in India. And their journey was one where everyone abdicated their responsibilities, from the state to the judiciary to the prosecuting agency, everyone. By the time it was transferred to Delhi and we took over the case, we had already lost some 15 or 17 years. We lost the first round in the trial court. The High Court then reversed the order of acquittal. The matter is now pending in the Supreme Court, where we will again appear for the victims. So I think the only thing I can say is that this is something that all seniors must do. This is something that we owe back to the profession. It is all very well to earn money, which you must, and I have no contestation with that. It is all very well to represent corporate clients, but when you are asked to represent people who can't get that kind of representation, you should never turn your back on them. I also have very strong ideological positions, and therefore when I see that something is gravely wrong, I don't hesitate to take up those matters.
Thank you, ma'am. That actually echoes the sentiment of the National Legal Services Authority and their call for more seniors to come and represent legal aid victims. And it's so welcoming to see that you've been following that approach throughout your career. And I hope these words inspire more such seniors and junior advocates to take on such matters. Moving on from there, you've also held the role of special public prosecutor in certain cases, and more recently, and what the world has their eyes on currently, the amicus position in the marital rape exception matter. So as younger lawyers, we want to understand the role of an amicus in such a case, where it comes to striking down of constitutional provisions or finding exceptions. What role should the amicus play? And is the appointment of an amicus a way to balance arguments from either side by the court? So what do you think is best represents such a role in these type of matters?
So the typical, amicus curiae means friend of a court. When someone is appointed as an amicus, particularly in these kind of matters, you're appointed because you're an expert in that area of law. I don't think the fact that you vote for one side or the other, I don't necessarily see these proceedings as adversarial, firstly. Secondly, in a matter like this, in fact, my appointment order clearly stated that they are appointing me, the court is appointing me solely because of my expertise in criminal law. And they wanted to understand the provision from a criminal lawyer's perspective and from the perspective of how it is incorporated as a provision in the IPC. My arguments were rooted in criminal law. I had a position only because my arguments could not, the way I structured my arguments, it could not sustain the exception any longer with the provision. Of course, it is for a court to decide whether it is constitutionally permissible for it to strike it down or to hold it. That is entirely the remit of the court. But as Justice Chandrachud has said in the iconic Joseph Shine judgment, which is a Constitution bench judgment which struck down adultery as a discriminatory provision in the Indian Penal Code, sometimes you cannot be neutral, and you have to judge neutrality from the point of view of history, the positioning of subjects, etc. So this kind of false neutrality, which is sought to be foisted on an amicus, actually is unnecessary. It's just diverting the debate. In a given case, you can argue against the more popular position. In another case, essentially, my arguments were legal, and it had nothing to do with any position I may or may not have. And the legal argument was substantiated by a historical argument as to why and how this provision came into being, what were the objects and reasons why this provision came into being, and then it was nuanced in the present day context. So a legal argument is what the court expects from an amicus, and positioning is really not something that anyone really bothers about. Everybody has a position, and even judges have positions. But then those positions must be positions that can be sustained and corroborated, and must have a meaning. It must have some kind of meaning within the four corners of laws. Otherwise, that position is meaningless. So if I'm not able to corroborate the arguments legally, just because I have a position, it is of no consequence.
Thank you, ma'am.
In the context of this present debate, when a court is asking whether this provision should be deleted as being unconstitutional or not, you have to take a stand. You can't say, do what you want to. It can be deleted, but it should remain. So you have to take a stand. You can't be in this no man's territory. But that stand, as I say, is based on research, legal research, historical research, judgments of the Supreme Court. You have to contextualize it from a constitutional point of view, and only then place your position before court. If it is uncorroborated by these materials, then that position has no bearing. But if you are seeking to rely on jurisprudential material which supports your position, then of course the court looks into it. But you can't be in this I support it but I don't support it land.
Yeah, absolutely. It wouldn't, you wouldn't
It's
be
untenable. It's completely untenable.
Yeah,
But
absolutely.
even I don't really want to comment more about it because it is an ongoing position. It is an ongoing case. But even within the position I took, there were concerns which I highlighted before the court, and those concerns come from my experience as a criminal lawyer.
Mm-hmm. Yeah.
So it wasn't a wholly one-sided position. While I argued for the deletion, my position was nuanced in the sense that I did say that these were concerns I had, and these concerns must be taken into account while coming to a final decision.
Understood, ma'am. Moving on from that, the other landmark recent decision, which has really defined how women, feel empowered in terms of bringing matters forth, is the Priya Ramani matter and the Me Too movement. From your experience of handling the matter as younger lawyers, it would be great for us to know what your approach was while, dealing with that case, and if you think there's something different the court could have done than what it did.
So firstly, I must say that the complainant has moved an appeal in the High Court, and the appeal has been admitted. It will come up in normal course. So we still haven't heard the last word on the topic judicially. So we must bear that in mind as a caveat. However, round one was won by us. I didn't represent, I represented an accused in that case. Priya Ramani was an accused. She was not the complainant in that case, ironically. So when Priya came to me, she was in possession of certain corroborative materials, which really made her case a strong case, a very, very contestable case. And so it was my job essentially to structure her defense in a way that presented her defense in a robust manner. 499 of the IPC is a very peculiar provision. It defines defamation, but it also has a set of exceptions, which I would request all young lawyers to read. An exception in criminal law essentially means that if you were to plead that exception, any one of those exceptions or a combination of those exceptions, then you have to lead evidence to justify the pleading of that exception. The Supreme Court also, in many cases, have said that while the onus shifts on the accused to prove the exception that you are seeking to invoke, the standard of proof is lower than the standard of proof that is required from a prosecuting or complaining side. So Priya Ramani pleaded truth as her exception, as her defense, truth made in public interest for public good. This is exception 1, 3, and 9 to 499 of the IPC. So therefore, she then had to take the witness stand. She came as a witness in her own defense, and she gave her testimony on oath around the circumstances under which the incident took place. She explained her tweets, and she also produced corroborative material, which was then further corroborated by the person in whom she had confided. She appeared as defense witness number 2. And since the challenge was about the reputation of an individual, we produced a third witness who did not corroborate Priya's story. She wasn't even around when the incident with respect to Priya took place, but was a subsequent employee in the newspaper. And she had her own story of sexual harassment to tell. In this way, we had a two-pronged attack to the complaint. One was the defense that Priya pleaded, one of truth, made in public interest and for public good. And the second was to disprove the contention of the complainant that his reputation had been harmed and that he was a man of impeccable reputation. So we took these parallel defenses and merged them. And on a examination of the two, the court came to the conclusion that the defense taken by Priya Ramani was credible. The test laid down by the Supreme Court of proof on the threshold of preponderance of probability was met, and therefore she deserved to be acquitted. What is important here is that it could be ex facie defamatory. It could be defamatory, whatever you have said, but in the context of the defense that you are pleading, it is not defamation if it is the truth made in public interest and for public good. So it's no one's case that calling out sexual harassment is not something which is a matter of public interest. And therefore, we were able to merge these defenses within the four corners of the exceptions to 499.
I also wanted to ask you about the Jagdish Titler matter, because that's something which continuously pops up in the news. For example, he's just been made a permanent member at one of the Congress committees, and there are certain key witnesses who still face threats. So in such cases, is there something courts can do above and beyond passing an order of, granting witness protection, which may or may not follow through over the years? Is there something, in your opinion, they could do more?
So let me clarify that I appeared in this matter, I think some 15 years ago, when the issue of the closure report filed by the CBI before court was being contested by the complainant witness, and we had filed a protest petition, and we were trying to contest the findings in the closure report. And after that, I haven't really appeared in the matter because nothing really happened. But in the context of witness protection, I think this is a very serious problem because we've seen it across cases and across the country, that witnesses to grievous crimes are very, very vulnerable, particularly if the other side is politically and socially and economically powerful. There is, in the recent Hathras case, for example, we saw the manner in which the complaining girl was cremated against the express wishes of her parents. So I think although courts have formulated many guidelines for witness protection, and many courts make those guidelines part of their rules and orders, something more needs to be done, and the protection of the witness must commence from the time he or she goes to the police station to register an FIR, particularly in cases where the opposite side is very, very powerful and it is not a level playing field. Unfortunately, in a lot of these cases, the prosecuting side is not really committed to the cause of the victim. And that's why the victim's vulnerability is exposed in the manner in which it is. These are deep-rooted problems. It is interconnected with police reforms. It is interconnected with prosecutorial independence. And so there are no easy solutions as of today, except that we should not be satisfied with just mere guidelines. It is something which needs to be urgently considered, creatively considered, and it is a mix of reforms. It's not just one area that we should concentrate on, from police reforms to prosecutorial independence to witness protection. These are all interconnected. And unless we focus our attention on all three, we are not going to reach anywhere.
Yes, thank you, ma'am, completely. The other thing all of us, as younger professionals wanted to know from you is, as a lawyer who's grown in the profession over these years, what impediments have you seen, systematically that women face in terms of, greater appearances or playing greater roles in this profession? And how do you think things have, even if so, improved slightly throughout the course of your career?
So the one great magical thing that I see in courts today, of course, we don't have physical courts and we've had it intermittently over the last 2 years. But what I do see is a lot many women lawyers coming to courts, and that's a really pleasant sight. And it's very encouraging to see younger lawyers, particularly confident young women, walk through the corridors of the courts. Where does this, is this consistent? Where does this fail? Well, up until a point, I think, firstly, we have to accept the fact that even today, despite the successes of some women in some areas of law, this is a deeply male space, the legal profession. And largely, if you go out of even the bigger cities, so assuming that the bigger cities give a semblance of equality to men and women as lawyers, when you go outside the bigger cities, women actually disappear from the space. So they are used to carry the files of their seniors, and they have some peripheral roles, but they are not allowed to develop and come into their own and practice as independent lawyers with a voice and a head, and they don't generate any interest either amongst their peers or from the court. That is a problem. We must also recognize the fact that discrimination exists at many levels. There is intersectional discrimination. So women like me are privileged. We come from privileged backgrounds. But there are women across the country whose life stories are very different from mine or yours. And that is something we must acknowledge, even as women, leave alone the acknowledgement from men. So the women who have somewhat done well, whatever that means, are women who came from privileged backgrounds. And there must be an acknowledgement of the fact that we've come from privileged backgrounds. Aside from that, I think, speaking from my experience and looking at friends and colleagues like me, as I said, this is a deeply male space. And so long as you don't threaten that space, it's fine. But the minute you threaten that space, men like to slot you. Your own male colleagues like to slot you. And so they would love to slot me as a criminal lawyer, senior criminal lawyer, who largely appears for women's causes. I have no problems bearing, I would accept that as a compliment. Because I do appear very strongly for women's causes. But they fail to recognize the fact that my work actually is similar to theirs. I've done everything that they have done and more. So I have appeared for accused persons in a wide variety of cases, from corporate crimes to strict liability offenses, to crimes against the body, to crimes against property, everything, the entire gamut. I've done trials, I've done cross-examinations, I've done appeals, I've done final arguments, I've appeared in every court in this city. So when you slot people, which is what men do, The reason why they slot you is to show you as a soft person, as a soft lawyer. Whereas the women who are largely occupying some of the senior positions, both in the High Court as well as the Supreme Court, are women who have traveled the distance and done exactly the same kind of matters as the men. But because men feel threatened sometimes, not all men, but some men, because they feel threatened, there is a tendency to slot you and to treat you as someone who has done soft cases. Speaking for women or speaking for the underprivileged, I would imagine, is the duty and responsibility of all of us, men, women included. I have always said that criminal trials should be humanized and feminized. When I use the word feminized, it equally applies to men and women. Feminism is a way of life. It's not something which only women, it's not something that only applies to women. So a lot of my male colleagues in the office always say, we are also feminists, because that's what we aspire to be. We want an element of humanity to be translated into the work that we do. So while I accept the honor of being slotted as a women's rights lawyer, and I accept it with great great humility, and I would say I'm privileged to do that work. My only response is, that's not the only work I've done. I have done everything and more that male lawyers in my position have done.
Absolutely. Thank you, ma'am. And it's so inspiring to hear that male colleagues in your office identify as feminists, because that is the only way we can have a more equitable system. You cannot pay lip service by just employing or having representation of women when you don't actually believe in feminism.
Absolutely.
So it's heartening to hear.
Absolutely.
As a closing question, I just wanted to know, given this situation and given this slotting, what advice do you have for young female lawyers? And, what should they do to be able to avoid certain circumstances if they can?
So in the beginning, the journey is kind of similar for men and women, give or take a few differences. But it is a long journey. This is an exacting profession. It takes a lot out of you. You keep long hours. You have to constantly read and update yourself about the changes in the law. Every second case is a learning experience, because you are exposed to a law that you hadn't been exposed to earlier. So you never stop learning in the legal profession. And my advice to young lawyers, men and women, is that you should not be in a hurry. I always say, I see a tendency today. You come out of law school one day, and the fourth day you've set up a law firm. Whereas you should be using the first few years of your time training intensely and developing skills. Because if you don't have skills, then at least as a litigator, you are not going to succeed, man or woman. If you have the skills, and if you have, so you should take this time to train rigorously, to read, to hone your skills, and not be in a tearing hurry to achieve some unachievable targets. I spent 10 years of my life, of my early years in my career, training under a senior. And I don't regret one single moment of it, because I am what I am today because of that intense training that I went through on a daily basis in an office that dealt with these kind of cases. And so never underestimate the importance of training, and never underestimate the fact that you need to develop skills. If you don't develop skills, then you are not going to be the complete lawyer. even at my level and at my age, I am constantly learning, constantly reading, constantly trying to update developments, not just in our country but across the world. For example, if you are dealing with forensic science, which criminal lawyers have to deal with all the time, what is the position with respect to voice samples across the world? What is the position with respect to DNA evidence across the world? What is the position with respect to fancy words like artificial intelligence, etc., which is thrown at us time and again across the world? Have these been validated scientifically? What are the scientific developments? All of this becomes very important when you argue these matters in courts, particularly at the stage of cross-examination, when you are challenging an expert. So I think reading, assimilating knowledge, there is no shelf life for that. You can do it throughout your life. And I would only request younger people to be more invested in the work that they are doing. As far as young women are concerned, just learn to ignore the chatter around you. There will always be people who will pull you down. Ignore it. You have to develop a thick skin, a thick hide, but you will. Believe me, you will. There will be times when you feel let down and hurt, and you ask yourself, is this worth it? Believe me, it is. It is a profession which gives you a lot of satisfaction, sometimes even joy. Wait for that moment. It will be there. You will get it. Don't let people tell you that you're not good enough, because you are.
Thank you so much, ma'am. And in the spirit for waiting for the joy whenever it may come, thank you for your time and thank you for speaking to her forum. This has been really, really insightful.
Thank you. Thank you so much.